are so basically for study sessions, what we do is go over any areas that you questions that you want to go over in the various topics that will be on your exam. And feel free to put your answers in the chat, like if it's A, B, C, or D, and I'll copy and paste all of the questions and the question rationale in the chat for you guys to reference. Yeah, so these are the various topics. Let me know if any stick out to you that you want to start with. Feel free to say it out loud or put it in the chat. Any specific ones you guys want to go over? Sure. So I'm trying to think. So we can go ahead and we'll pop into the okay. Yeah, thank you for letting me know. They can hear me. So want to do property and disclosures. We'll start there. And then if there's any other topics you guys want to do. Okay. First question. Here, let me make it a little bigger for everyone to see. Okay. Listing agent Dustin holds an open house and puts air fresheners all over the home so that the pet odor is not so noticeable. Dustin advertises hardwood floors throughout that and are covered by carpet needing to be replaced. Of which hazard should Dustin warn customers of the open house? A. Radon, B. Lead, C. Biohazard from pet urine, or D. Formaldehyde insulation. All right. C. And C is correct. Good job. So it would be biohazard from pet urine. All right, next question. Controls on the development of areas designated as wetlands have become the subject of recent regulations because A, mosquitoes and other disease-carrying insects, which breed primarily in wetlands, need to be irradiated. B, wetlands are recognized as a natural resource necessary to maintain ecological balance in the environment. C, local governments have the primary responsibility on how wetlands can be developed. Or D, wetlands are a major source of flooding in certain areas of the country. Also, you'll get random questions like this on your exam, which you're like, how does this have anything to do with real estate? But just in case you are dealing with an area that has wetlands, always good to know this. I was gonna say I'm not sure what the right answer is, but I'll say B. It's a good guess. Good, yeah, B. So wetlands are recognized as a natural resource necessary to maintain ecological balance in the environment. All right, good job. And yeah, don't ever worry if you don't know the answer. Still feel free to put it in the chat. I probably half the time don't know these answers either. Okay. Oh, next question. All of the following are true regarding the National Flood Insurance Program, except A, unless required by a lender as a condition of the mortgage loan, coverage is not effective until 30 days after purchase of the policy. B, the program is administered by Federal Emergency Management Agency. C, the program covers loss or damage to personal property caused by a discharge or overflow of water from a plumbing, heating, or air conditioning system. Or D, if the property is located in a designated special flood hazard area, federally related loans require flood insurance. So all of the following are true regarding the National Flood Insurance Program, except which one? All right, we got it. Cool. All right. So A was definitely a good guess. B was the correct answer, which is the program covers loss or damage to personal property caused by discharge or overflow of water from a plumbing, heating, or air conditioning system. So that is not true regarding the National Flood Insurance Program. I guess that is good to know. But hopefully we never have to deal with that. All right. All of the following may be places where asbestos could be found in a single family home that is 50 years old, except A, in exterior siding, shingles, or roofing, B, in insulation sprayed around pipes and ducts or in attic insulation, C, vinyl flooring, material installed when the home was built, or D, recently purchased treated lumber for use in constructing decks. All right, we got D. Both of you said D. Okay, cool. Yep, good job. D is correct. Recently purchased treated lumber for use in constructing a deck. All right. Next question. Juanita is about to buy a house that was built prior to 1978. The seller should give her which disclosure? A, lead-based paint disclosure form. B, Miranda warning. C, closing statement. Or D, truth in lending statement. All right, good job. Glad you guys answered that so quickly because this is a required document that you will use when you have a listing or showing a house, or if you have something under contract. Awesome. Lead-based paint disclosure is correct. I'll just put the question rationale in the chat. All right, next question. All right, Agent Aaron is showing the seller's property to a prospective buyer who he also represents as a buyer's agent. While touring the home, the seller tells the prospective buyer that the basement is dry and has never flooded. Aaron remembers that during a recent rainstorm, the seller told the agent not to show the property because the basement had flooded. Under this circumstance, what would be the most appropriate action of this dual agent? Is that A, the agent should do nothing unless the buyer decides to make an offer? B, the agent should say nothing, being quiet absolves the agent of liability. C, the agent should speak up and correct the misinformation the agent owes the notice of material fact to both the buyer and seller. Or D, the agent should not dispute the seller's word. The agent has an obligation of loyalty to the seller's best interest. Like that. See? C is correct. Good job. Agent Aaron should speak up. The agent owes duties and confidentiality to both clients. But material defects are not confidential and must be disclosed. The question rationale is also super helpful to um, reference because it does say key things about definition in it, and it could be useful for future questions and good to study. Which best describes an allergen? A, relating to or sand deposited by flowing water. B, the capacity of bases to neutralize acids. C, the condition of water or soil which contains a sufficient amount of alkali substance to raise the pH above 70. Or D, a substance that causes an allergic reaction in individuals sensitive to it. All right, I was going to say D too. All right, good job. Yep, D is the correct answer. A substance that causes allergic reaction in individuals sensitive to it. An agency disclosure is necessary to let the A, seller know the agent represents the broker, B, client know the agent represents her, C, buyer know the agent represents the broker, or D, customer know the agent represents her. This is kind of a tricky one. I think someone said B first. B is correct. An agency disclosure is necessary to let the client know the agent represents her. And then in the question rationale, it says the agency disclosure form lets the client know who represents her. A customer is not represented by anyone. So a client is somebody who you represent, and then a customer is not represented by anyone. And a customer can always turn into a client. Okay. The disclosure of the relationship in which one party acts for or represents another under the authority of the latter is known as A, agency disclosure, B, actual notice, C, abatement, or D, customer representation. So based off the last question. All right, good job. It is A, agency disclosure. Sometimes they'll use agent, sometimes they'll use client. So client equals principal. That's actually very helpful knowing that client and principal are the same thing. And I'm sure the test will use both throughout. But just knowing they're the same, they mean the same thing. All right, next question. Federal regulations require real estate professionals and property owners to provide specific disclosure language and forms to purchasers and prospective tenants of single-family housing constructed prior to the 1978 regarding the presence of A, asbestos, B, lead-based paint, C, mold, or D, radon. What's that disclosure that we need to make a deal happen? And all properties that were built prior to 1978. All right, good job. It is lead-based paint. If they're built after 1978, you will not need a lead-based paint disclosure. Cool, good job, guys. All right, what topic should we do next? Feel free to put in the chat, say it out loud. So we just did property conditions and disclosure.
Maybe transfer of title.
Okay, sounds good. Yeah, this is a good one. Cool. Oh wow, there's only 5 questions. We can do like 2 rounds of this. Okay, the successive conveyance affecting a particular parcel of land arranged consecutively from the original source of ownership to the present day owner are called A, certificate of title, B, chain of title, C, estoppel certificate, or D, abstract of title. So the successive conveyance affecting a particular parcel of land arranged consecutively from the original source of ownership to the present day owner are called what? Right? Good job. I would say B as well, and B is correct. Cool. I always mix up A and B. So yeah, so B, so anything you see consecutively or arranged in like chronological order, chain of title is going to be the answer. A chain of title is a string of successive deeds in chronological order, tracing ownership from the original source to the present owner. Cool. Good job. Okay, next question. Standard title insurance covers A, defects disclosed by the competent survey, B, all title defects, C, recorded title defects, or D, unrecorded title defects. Oh, this is, I'm sure if you see, I'm petting my dog Moose. He's joining the Zoom chat. Okay, yeah, this is a tricky one. Let's see myself first. So it is C. C, recorded title defects. You would think it covers all title defects, but the standard title insurance covers recorded title defects. So standard title insurance will cover only those defects that could be found by a search of public records. Guarantee or extended title insurance would cover non-disclosure defects of record and survey defects. Okay, good job. Next question. David asks his lawyer for a certificate of title on a property he is about to buy. What is David asking his attorney to do? A, issue a certificate so David knows he is entitled to a deed on confirmation of sale by a court in a foreclosure action. B, review an abstract of title and give an opinion to David as to who the owner of the property is. C, give David a document that states David can now make improvements to the property. Or D, issue a certificate so David knows exactly how much is still owed on the mortgage and that the bank can no longer contest the amount owed. Where's my dog? She was the loudest toy. No, it's not. All right. B and D. Okay, yeah, good job. I was not sure which one was correct either. So B is the correct answer. Good job. So review an abstract of title and give an opinion to David as to who the owner of the property is. So a certificate of title, also known as an opinion letter, is given by an attorney after examining an abstract of title stating the attorney's opinion as to who owns a particular property. All right, good job. Yeah, this one could be confusing. So chain of title is going to be the chronological order of who first owned the property to who currently owns. And then certificate of title is going to be what an attorney handles, and that's also called an opinion letter. So definitely knowing the difference between the two. Right. Bob's lawyer examines an abstract of title and gives him the opinion that the title is vested in William. This opinion is called A, certificate of no defense, B, certificate of sale, C, chain of title, D, certificate of title. All right, good job. Exactly. So it's going to be certificate of title. So certificate of title, also known as opinion letter. Okay, next question. How could a trespasser become the owner of real property? A, easement appurtenant. B, affidavit of title. C, adverse possession. D, easement by prescription. All right, we got C. Yeah. For some reason, I always remember this one too. So yes, it is adverse possession. The open, notorious, hostile, and uninterrupted possession of the property of another under claim of title will gain even a trespasser the ownership as long as they satisfied the prescribed number of years for adverse possession. Which is crazy to think, but okay. Okay, good job. Okay, we can do another round of transfer of title, or if there's another topic you guys want to go over. From leasing, property. Okay, another round. Cool. All right. Let's do another round of transfer of title. Sounds good. So when a buyer asks the seller to provide title insurance and they agree, who picks the title insurance company? A, either seller or buyer. B, buyer or buyer's agent. C, seller. Or D, lender bank. Now we have B. So it is C. So if the seller is providing it, this one was a tricky one. But when a buyer asks the seller to provide title insurance and they agree, it would be the seller who would choose it. So the owner's title insurance policy would be chosen by the party paying for the policy. So yeah, that was a tricky one by how they worded it. So when the seller is paying the buyer's closing costs or the seller agrees to provide the insurance to the buyer, it is the seller's responsibility to insure the title for the new owner. But like normally it would be the buyer to choose, and then the buyer's agent would suggest. But in this circumstance, since the seller is providing the title insurance, the seller chooses. Okay. An instrument in writing that transfers ownership of tangible property is called A, bill of sale, B, mortgage, C, blanket mortgage, D, listing. All right, we got A. A is correct. So it would be a bill of sale. And that transfers only tangible property, for example, furniture, while a real estate contract is a contract to transfer real estate. Okay, good job. Next question. A mortgage company typically requires title insurance to cover the A, mortgagee, B, mortgagee and mortgager, C, mortgager, or D, seller. So a mortgage company typically requires title insurance to cover the what? It get a little confusing. Right, so it'd be mortgagee. The and this one was hard. I was not sure. So the mortgage company, which is the mortgagee, requires insurance only to protect itself. It may be advisable or even customary for insurance to be purchased for the borrower, which is the mortgagor, but is usually not required. So just knowing that the mortgage company, okay, so let's see, mortgage company equals the mortgagee, and they require that title insurance covers them. And then the client who's taking the loan is going to be the mortgagor. And this will definitely be on your exam. Yes, I totally confused it. I still confuse this, so I'm glad we went over this. So so mortgage company is going to be mortgagee, and then the borrower is going to be mortgagor. Oh, that's a good one. So borrower, think of mortgagor, and then mortgage is just mortgagee with an extra E, maybe. I don't know. Okay. But yeah, definitely knowing this for the exam is super helpful. Oh, I just typed that all in and it was already typed in the question rationale. Cool. A title search can be conducted by A, an attorney, B, a buyer's real estate agent looking after the client's interest, C, anyone, D, the loan processor. Right. So shockingly, a title search can be done or can be conducted by anyone. So anyone can go to the public record and search a title. If the question asked who prepares the evidence of marketable title, then an attorney at law would be the right answer. So a title search can be conducted by anyone, but if it says who prepares the evidence of marketable title, it has to be attorney at law. Yes, yeah, that one's kind of confusing, but then again, you're like, where do I do a title search? And normally that's through the county website, and I didn't know that until I was able to do it. So yes, that also may be on your exam. Title to real estate is transferred when a deed is A, signed, B, recorded, C, acknowledged, or D, delivered and accepted. So title to real estate is transferred when a deed is what? Can be recorded? So it would be D, delivered and accepted. So while a deed must be signed by the grantor and acknowledged by the grantor in front of a notary, a deed does not have to be recorded. The transfer title occurs when the deed is physically given to the buyer and the buyer accepts. So this is kind of confusing, especially when the steps of a deed recorded is one of them. So when it actually transfers is the key term here to know that the deed actually transfers when the buyer accepts, when the buyer receives it and accepts it. Okay, good job. Those are tricky. All right. Which topic should we do next? Anything specific you guys find tricky or want to go over? All right, property ownership. Sounds good. Okay. A valid encumbrance affecting title of estate and land, such as a mortgage or judgment, is called A, cloud on title, B, chattel mortgage, C, condemnation, or D, contract of deed. Also, whenever reading the question and then the answers, doing process of elimination is super helpful when choosing the best answer. Okay, cool. And A is correct. A cloud on title means the property is not clear from liens. And an encumbrance is any claim, lien, or charge or liability that affects or limits the fee simple title to real property. Okay, good job. Next question. To find out whether there is an encroachment on a property, a person should purchase A, a survey, B, a mortgage insurance, C, title insurance, or D, homeowner's insurance. All right, we got A, and that is correct. Good job. So a survey would show any physical encroachment on the property. Good job. For a buyer to be certain that the property has no encroachments, they should obtain, which is the same question, kind of, A, owner fee policy of title, B, survey, C, certificate of no defense, or D, abstract of title. All right, good job. Again, it's going to be survey. Back-to-back survey questions. So hopefully that's on the test because you guys know it. So an encroachment of property, to make sure there's none, order a survey. Or to make sure and see if there's any, order a survey. And that is a professional surveyor is going to go ahead and do that. So which statement regarding the common area of a condominium project is true? A, the common area in a condominium is owned by the government and does not require insurance coverage. B, the owners insure only their own individual units and the common areas are left uninsured. C, each owner maintains an individual policy over the common areas. Or D, the homeowners association usually has liability insurance coverage for a common area. All right, good job. Yep, and D is going to be correct. So the common area usually has liability insurance paid by the condominium homeowners insurance. Another abbreviation for homeowners insurance is going to be an HOA. Okay. Tom and Sally are not married, but own a rental property together. Because they also have a right of survivorship, they most likely own the property in A, tenancy by the entireties, B, joint tenancy, C, tenancy in common, or D, tenancy in severalty. Similar questions will be on the exam, so kind of knowing the difference between each one. All right, we got B. All right, good job. B is correct. Tenancy by entireties requires the couple to be married and living in the home. Tenancy in common and tenancy in severity do not have right of survivorship. And then severity is ownership by one, and then joint tenancy is a form of co-ownership in which co-owners have equal undivided interest in the right of survivorship. Good job. This question rationale is super helpful in explaining the difference between each one. Okay, next question. When a person has an interest in land that will only continue as long as they live, they have A life estate, B estate for years, C simple estate, or D easement. All right, good job. A life estate. All right, so the question rationale says, don't confuse a life estate with dower, which is a form of a life estate that grants a percentage of a deceased spouse's property. B simple estate is outright ownership, and an easement is the right to use another's property, to use another person's real property for a particular purpose. And an estate for years describes a leasehold estate with a specific termination date. Okay, well, hopefully that doesn't confuse you, but yes. So when a person has interest in land that will only continue as long as they live, they have a life estate. Fixtures and showcases attached to property in a store and occupies rented space are considered A, chatels, B, all of the answers listed, C, personal property, or D, trade fixtures. We have D. All right, so it's actually going to be all of the answers listed. So trade fixtures are fixtures that can be removed at any time, and then they are considered personal property or chatels of the tenant. And then chatels are personal property, and then property that is not real and can be described as chatels and personal property. So all of the answers listed are basically the same thing. So, for example, I think they use the example of a hair salon. Having hair salon sinks in there are all going to be chatels. They're all going to be personal property, and they're all going to be trade fixtures. So when that hair salon no longer wants to be at that location, go somewhere else, they can go ahead and take their what did I say? Their sinks, their hair salon sinks that they use. So kind of like putting it into real life terms, their example is helpful to answer this question. So chatels, personal property, and trade fixtures are going to be one and the same. They're able to be moved, and that person would have put them in the property. Okay. Next question. A system of ownership and fee simple title to be designated areas of airspace with a percentage of ownership of common elements in the property is termed a chattel, B, cooperative, C, condemnation, D, condominium. All right, D is correct. Yep. Very random, but good to know. That designated areas of airspace with a percentage of ownership of common elements in the property is termed a condominium. Okay. Which would be considered a chatel? A, new furnace, B, fence, C, in-ground swimming pool, D, goods or other items of personal property not annexed to real property. All right, good job. D is correct. Chatels are personal property goods or other items of personal, movable or immovable that are not real property. Okay. Next question. One of the appurtenances to a parcel of land would be a bill of sale, A, bill of sale, B, assignment, C, bundle of rights, or D, deed. I don't remember what this one is. All right, so it's going to be C, bundle of rights. The bundle of rights are legal rights conferred to owners of real property, including the right to mortgage, sell, lease, improve, enjoy, and use the property. They run with the land and thus are opportunent to it. I never know if I'm saying that right, but yes. So it's going to be the bundle of rights. And again, the bundle of rights includes mortgage, sell, lease, improve, enjoy, and use the property, and they run with the land. Okay, cool. Good job. Okay, I think we have time for one more. There's one that sticks out. We can do another. All right, leasing and property management. Sounds good. Okay. What type of lease would you expect a residential property manager to execute on behalf of his or her landlord? Is that going to be A, percentage lease, B, gross lease, C, land lease, or D, net lease? So what type of lease would you expect a residential property manager to execute on behalf of his or her landlord? Yes, and definitely knowing the difference between each lease. I mean, obviously would help with this question, but will be very helpful for the test. Okay, so it's going to be a gross lease. And what that means is a gross lease is usually used in apartment setting. The tenant pays a gross amount of rent over monthly installments. For example, 6,000 in annual rent payable in 12 equal installments of 500 on the first of each month. So then a percentage lease is usually used in retail, where the rent is based on the percentage of the sales made by the tenant each month. And then a net lease is usually heavy manufacturing. The tenant pays not only rent, but also the landlord's taxes, insurance on the building, and all utilities. And then a land lease is usually used by a farmer leasing land to another farmer or by a homeowner who owns a house, but not the land in which the house was built. Never really want to uh, buy a house if you have a land lease on it, because then you'll always have to be paying somebody for just the land that the house was built on. Okay, so this one is going to be gross lease. Next question. Which type of estate would a tenant receive from a landlord? Is that an A, fee simple absolute, B, life estate, C, tenancy at sufferance, or D, leasehold estate? All right, good job. It is going to be D, leasehold estate. Cool. Next question. What type of lease would be used when one farmer leases land to another farmer so that the second farmer can plant and harvest on it? All right, good job. Yeah. So it's going to be B, a land lease. Farmer equals land lease. The secretary for a property management company is authorized only to A, take a listing for new property management job, B, negotiate the leases, C, show rental units, or D, keep records. All right, good job. Keeping records is classified as clerical work and is part of the secretary's job. Cool. And next question. Which lease is most likely to be used for a retail dress shop? A, net lease, B, percentage lease, C, land lease, or D, gross lease? All right. I think it's A2. No, okay, so I know, right? It's going to be A between A and B, so I think it's B. Okay, so it's going to be B. A percentage lease would be used in a retail dress shop. Well, yeah, so knowing the difference between each lease, but then having an example for each one will be super helpful for your test. So the percentage lease is going to be, an example would be a retail dress shop where the tenant would pay a percentage of the sales at rent. A gross lease normally is for apartment buildings, or just renting an apartment. A net lease is going to be like a heavy industrial manufacturing, where in addition to not only the rent, they pay taxes, insurance, and utilities. And then the land lease is going to be, that example is going to be farmer. All right, cool. And we can go ahead and do this one. We can do leasing one more time. Okay, the broker's property management account must A, bear no interest, B, be part of the broker's trust account, C, be accessible by the property manager slash broker, or D, bear 6% interest. Okay, B. And so it is going, yeah, this was kind of tricky. So it's going to be accessible by the property manager slash broker. So the broker properties management account must be accessible by the property manager slash broker. And the law allows the broker to have a property management account that collects interest. Okay. A property manager is instructed not to show the property to anyone over the age of 40. This is in violation of the A, Federal Fair Housing Act, B, none of the answers, C, Equal Housing Opportunity Act, or D, Civil Rights Act of 1866. Okay, so it's actually a B, none of them. So a review. Okay, so they're trying to be tricky. So the Federal Fair Housing Act and Civil Rights Act of 1866 will show neither prohibits discrimination based on age. Secondly, if there was a commercial property, the Fair Housing Act would not apply at all. Age is protected class under the ECOA, not fair housing. All right, good to know. But C was my guess too, so I guess definitely knowing that age is not covered in Federal Fair Housing or Civil Rights Act. And then if age is mentioned, it's protected under ECOA, not fair housing. Okay. Next question. So ECOA is, I'm pretty sure that's the equal. We'll get up. Oh, wait, I thought so. So Equal Credit Opportunity Act. So they tricked us with whatever the other act they said. Yeah, I know. All right. So that was a good guess. A tenant's lease has expired. The tenant has neither vacated nor negotiated a renewal lease, and the landlord has declared that they do not want the tenant to remain in the building. This tenancy is called A, tenancy at will, B, estate of years, C, tenancy in common, or D, tenancy of suffering. All right, good job. It is going to be D, tenancy of suffering. Perfect. Good work. Next question. An investor asks the neighbor to help manage the investor's 4-unit apartment complex. The investor agrees to pay them $100 for each lease. The neighbor execute each lease the neighbor executes, sorry. May the neighbor manage the investor's property? No, because the neighbor needs a real estate license to manage this property. Yes, D, as the neighbor is exempt under the Mrs. Murphy's rule. C, yes, but only if the neighbor complies with the Federal Fair Housing Act. Or D, no, because the neighbor is a regular employee of the investor. Question. Hmm. Okay, this is a very bad question because technically, only an attorney can execute a contract. So, manager, yeah, I think it's A2. All right, cool. Perfect. Go with your gut. So it's going to be A. No, because the neighbor needs a real estate license to manage his property. So I think in order to get paid when managing real estate, you need a license or something worded like that. A lease can be terminated by A, expiration of the lease, B, refinancing, C, selling the building, or D, abandonment by the tenant. And that is correct. Good job. It's going to be expiration of the lease. A. Cool. Good job, guys. And thanks so much for joining. Appreciate the participation. You guys did great.